Attorneys usually don't take on cases for people who are still employed for the company they're saying discriminated against them. Here's why. Hi, I'm James Sucks. I'm an employment law attorney, and I file a lot of EEOC charges against bad companies. One reason an attorney might not be taking on your claim is that you still want to stay employed with the company. 99% of these type of claims will end in a separation of employment. So if you still want to stay with the company for whatever reason, it's not as realistic for attorneys to work with. Another big reason might be because you haven't really had an adverse employment action yet. An adverse employment action is that thing that we need to show discrimination in an employment case. And usually an adverse employment action is going to be getting terminated. So without that and you still being employed, it's a lot harder to try and navigate an employment case. The last thing may be you might not have enough damages to justify an attorney getting involved with your claim. So if you don't have lost wages, which is a big part of employment claims, it's hard for attorneys to take on a claim for you. This doesn't mean that it's impossible for you to get an attorney though. It's just going to be more difficult because of those factors. And you can still always file a charge with the EEOC regardless of what your employment status is. Remember to like and follow for more content like this. And if your boss sucks, call Hux.